Welcome to the Chapter 7 video lecture. This chapter deals with parties to a crime and criminal liability. So the kind of first main principle to think about is complicity. This is essentially asking the question, when are you liable for someone else's conduct? And we have two main times where you could be liable for someone else's conduct. The times are when you are an accomplice or when you are an accessory. Accomplices, and this is based on two kind of theories. The first is, or three theories actually. The first is vicarious liability, in that you are criminally responsible for someone else's crime because of a relationship, and so that transfers over the criminal conduct from one person to another. So employer to employee, things like that. That relationship shifts responsibility. Agency theory deals with the idea that we're each kind of autonomous individuals. We can have free will, but when we choose to join in and participate in criminal activity with somebody else, then you can become liable for their conduct. And the last idea is forfeited identity theory. And under this particular theory, the thought is that you forfeit your right to your own individual identity when you choose to engage in criminal behavior. Therefore, you are responsible for the outcome as a whole. And so there are two and there's kind of two frameworks where this happens, that the result is either you're an accomplice or you're an accessory. You're an accomplice or an accessory under the codified law. Under the common law, though, before we got there, we had four different groups. You were a principal in the first degree, which is the person who actually commits the crime. So we could even just note here, person who commits crime. And the principal in the second degree is the person is present when the crime is committed and helps commit it. So this would include lookouts and getaway drivers, because they are there when the crime is committed and they're assisting with it. Meanwhile, accessories before the fact aren't present but help before the crime was committed. And accessories after the fact are persons who aren't present but help after the crime was committed. So accessories might help provide materials to commit arson or things like that, while an accessory after the fact might help you hide from police or something along those lines. So those are kind of those are the four common law principles, but we've kind of collapsed those a little bit today to accomplices and accessories. So accomplice liability, your liability for the underlying harm attaches because you participated before and during the crime. Accessory liability attaches for someone who participates after the crime was committed. So thinking first about an accomplice, the elements of accomplice liability are that the accomplice engaged in the voluntary act of aiding, abetting, inciting, or encouraging another person to commit a crime, or they were present at the scene of the crime when there was a legal duty to intervene. The actus reus is that they had the intent to commit the actus reus, so general intent. There is a minority rule in some states, though, where they need to commit the crime itself, and that is the elements of accessory liability. So some things that might contribute or that might provide accomplice actus reus are words can be enough, and present, but just being mere presence at the scene, just being present and that's it, is not enough for criminal liability. And anything that is a positive aid in the act of the commission of offense is enough. This is pretty broad. Some things that definitely qualify as that positive act and aid would be providing supplies or weapons, instruments of crime, serving as a lookout, driving the getaway car, sending the victim to the person who actually commits the crime. So you're the intermediary that gets the victim from point A to the ultimate harm, or preventing the victim from receiving a warning. All of those things are sufficient actus reus. So if you know, words might qualify as the actus reus here, because maybe keeping the victim from getting a warning, all you have to do is say, hey, come here, I want to talk to you, and that stops the warning from getting through. It doesn't necessarily have to be like other physical actions. Now, there is one important distinction to make before we move on, and this is that accomplices are not co-conspirators. So conspiracy and accomplices are different. A co-conspirator is someone who has agreed to commit the crime, and so the conspiracy is the crime of agreeing to commit another crime. And the Pinkerton rule here is that the crime of conspiracy and the actual actionable behavior that results from the conspiracy, those are two separate crimes. So someone who commits maybe a conspiracy to engage in white-collar crime, to embezzle, the agreement to commit the embezzlement is one crime, and the actual embezzlement itself is a separate crime, which is different from being an accomplice, which is where you are participating either before or during the crime. Now, accomplice mens, so we talked about accomplice mens actus reus. Accomplice mens rea is either purposely or knowingly. It depends on your state, and if we look back at the elements, we can see that there is just this distinction in what is sufficient. So some examples of knowingly but not purposely helping someone is leasing an apartment to someone you know is going to use it for prostitution, gun dealer selling you a gun that they know you're going to use to shoot somebody, a farmer leasing 200 acres of farmland to someone that they know is going to grow marijuana. All of those kind of illustrate the distinction between knowingly helping someone, knowing and purposefully helping someone. Yeah, so I think that this, especially when you think about the examples, helps a lot. If you still have any questions, definitely reach out and let me know. Now, when you are, do we talk about this separate? Okay. Now, so the accomplice is before or during, and then an accessory is after. So the elements of being an accessory are that you aid a felon to avoid arrest, prosecution, or conviction, that you had the intent to help them avoid arrest, prosecution, or conviction, and so that's the criminal conduct. And then in most states, this is a misdemeanor, so you're going to spend less than 1 year in jail for this action. While if you are the accessory, you are usually charged as if you committed the crime itself. One important distinction about, and I guess before, your book has a really great case on being an accessory. It's the State v. Chisholm case, and here, if you walk through this, I think it's pretty clear about what it means to be an accessory versus being an accomplice. In this statute, the defendant was convicted of helping someone commit a felony, and without intervening, watching someone commit a felony in their presence, and he was convicted of it. So I'd encourage you to read through that. The next major topic in this chapter deals with vicarious liability a little bit more. So if we think back to the very beginning, vicarious liability is that you're responsible for someone else's actions due to a relationship. And one really common way that vicarious liability exists is through corporations, businesses. And it's under this idea of this, we have this legal fiction called respondent superior, where and that means let the master answer for the conduct of their insubordinate. So this kind of dates back a long time, as you can imagine, with that type of language. And an example of this principle is U.S. v. Arthur Anderson in 2005. Arthur Anderson was an accounting and consulting firm that participated in Enron's corporate fraud that they committed earlier. They were the auditing company of the corporate accounts, and they just kind of rubber stamped things in a lot of ways instead of alerting people that they were kind of cooking the book, so to speak. So they were responsible for the harm that they engaged in under this doctrine in the trial court and the appellate court. But the U.S. Supreme Court overturned it. They overturned the verdict. These types of cases often deal with big corporations, but there is an example in your textbook where the example is a fraternity. And the question is the fraternity, they were holding a big house party, and were they responsible for the sale of alcohol to minors and permitting prostitution? And the defendant, the fraternity was convicted of this, of permitting alcohol sales to minors and participating in prostitution, and the conviction was ultimately affirmed. So this is just a different example of vicarious liability, outside of that corporate context. Another issue of vicarious liability is that sometimes parents are vicariously liable for their children's crimes because of their responsibility, because of their parental relationship. They can be guilty for letting their kids snowmobile or drink and drive, knowingly drink and drive. So this chapter has a lot of distinctions between the common law and the current state of the law. So if as you work through this you find any questions, please reach out and let me know. I look forward to working with you this week.